In September 2025, Angela Rayner resigned after being found to have breached the Ministerial Code. She's not the first minister to have done so. In fact, it's a relatively common occurrence in British politics for ministers to resign for breaching the Ministerial Code. But does this Ministerial Code legally require ministers to resign? Or is it some other type of pressure or obligation in operation? And what does this tell us about sources of the British Constitution as a whole? The Ministerial Code is a 38-page guide issued by the Prime Minister which sets out how government ministers should discharge their duties and conduct themselves in office. Importantly, the Ministerial Code is not legally binding. Rather, it's a collection of rules that we call conventions. Conventions in the British Constitution are non-legal rules about how government should be conducted. By non-legal, I mean that they are not enforceable by a court, nor is conduct that breaches a convention illegal. Rather, the adverse consequences of breaching a convention are political rather than legal. The Ministerial Code is just one example of a convention in the British Constitution. Conventions, in fact, are so important that they've been described as the morality of the Constitution. They embody the idea that under the British Constitution, political actors should largely be held accountable by other political actors. Under this understanding, a democracy should put its trust in elected officials rather than unelected judges. And conventions are actually key to ensuring that the UK is a democratic state, and that power is held and exercised by elected politicians rather than the unelected hereditary king. For example, in the UK, after a general election, the leader of the political party that wins the most seats becomes Prime Minister. They're invited to do so by the king. But there is no legal rule stating this. Rather, this is the result of a political practice that has been followed for many years, and it would be very surprising and extremely controversial if the king were to do otherwise. In fact, the office of Prime Minister is itself a creature of convention. No statute was enacted creating this office, it emerged gradually over time, through practice. Likewise, the king can legally refuse to grant royal assent to a bill passed by the House of Commons and House of Lords. But in reality, no monarch has done so in over 300 years. Just think of the political controversy that would occur if an unelected monarch effectively vetoed a piece of legislation supported by the Democratic House of Commons. It is these adverse consequences rather than a legal rule that controls the monarch's behaviour, both in terms of the granting of royal assent to a bill and in terms of who becomes Prime Minister. But importantly, not every political practice is a convention. The constitutional scholar Ivor Jennings famously set out a 3-stage test to assess whether a mere practice constitutes a convention. The test is, firstly, what precedent, if any, is there for the practice? Secondly, do those adhering to the precedent believe that they are bound to do so, as if by a rule? And finally, is there a reason for the rule? Clauses 2 and 3 are key to distinguishing a practice from a convention. So, for example, you might have a coffee every morning, but that doesn't mean you're obliged to do so. Maybe you just like coffee. Your liking of coffee is a reason for your practice of drinking coffee every morning, but importantly, it's not a moral reason or even a contractual reason. So you're not actually bound to have your cup of coffee every morning, and so it's not a convention. Let's contrast this with an example of etiquette. How you're supposed to eat food when you're out with friends or in public. Take for example the eating of soup with a spoon. Yes, there is an established practice that you always eat soup with a spoon, and yes, you probably believe that you're obliged to do so. It would be inappropriate for you to drink the soup another way, for example by scooping it up with your hands. You think your friends would probably not like you anymore if you drank your soup like this. And finally, is there a reason for you to drink your soup with a spoon? Again, yes, it's neater, it's less messy, and it's much less likely to put your friends off their meal. And so we could say that a convention exists that when you're in a restaurant, you eat your soup with a spoon. But importantly, no law actually requires you to eat your soup with a spoon. It's not illegal for you to do otherwise. Rather, it's the adverse social consequences that you would feel that oblige you to eat your soup with your spoon. Legally, courts cannot enforce a convention, but courts can decide whether a convention exists or not, and this can affect how they interpret legislation in light of such a convention. Traditionally, conventions have been unwritten, but there has been a trend in recent years towards codifying conventions. The Ministerial Code is one such example. However, these codified conventions are still not legally binding, and so they are unenforceable in courts. Conventions also usually come to existence through practice over time. The monarch always granting royal assent to a bill is one example of this. But conventions can also come into existence through proclamation, that key constitutional actors will declare that a convention exists or that a power should be exercised in a specific way. An example of this is the Sewel Convention. During the debate on the Scotland Bill, the legislation that would create Scottish devolution and the Scottish Parliament, the House of Lords were discussing what could prevent the Westminster Parliament for legislating in areas that were devolved to the Scottish Parliament. The Government Minister Lord Sewel declared that we would expect a convention to be established that Westminster would not normally legislate with regard to devolved matters in Scotland without the consent of the Scottish Parliament. So far, so good. But what happens when conventions are breached? The above example of the King always granting royal assent to a bill, or the convention dictating who the King appoints as Prime Minister, would suggest that conventions are always followed. And these two certainly are, because of the extreme political consequences that could flow from their breach. They could cause a constitutional crisis that could throw the very existence of the monarchy into question. But not all conventions have such dire consequences, and certainly in recent years we've seen conventions breached on several occasions. So for example, while Angela Rayner resigned for breaching the Ministerial Code, in 2020 Prime Minister Boris Johnson refused to sack the then Home Secretary Priti Patel when she was found to have breached the Ministerial Code by bullying civil servants. Likewise, during Brexit, the Sewel Convention was breached on several occasions, as the Scottish Parliament refused consent to Brexit legislation that would have affected their devolved powers. What this means therefore is that the mere existence of a convention is perhaps not enough. Rather, we must also ask to what degree do constitutional actors feel compelled to follow the convention. This means therefore that some conventions are perhaps stronger than others. Sometimes it can also be unclear as to whether a convention exists or not. In March 2003, for example, the House of Commons voted to approve the government's proposals to invade Iraq. This vote was not legally required, as the deployment of British troops overseas is a decision for the government under the royal prerogative. And I will record a separate video on prerogative powers later in this series. The precedent that this vote set led Prime Minister Tony Blair in 2006 to state that the fact of the matter is that I cannot conceive of a situation in which a government is going to go to war except in circumstances where militarily, for the security of the country, it needs to act immediately without a full parliamentary debate. The Conservative Liberal Democratic coalition government from 2010 to 2015 appeared to act as if such a convention existed, with Parliament consulted 4 times on military action in Libya, Iraq and Syria. In August 2013, for example, the House voted against military action in Syria, and Prime Minister David Cameron agreed to abide by the resolution. However, just as it started to appear that a convention was in existence, cracks began to appear, starting in April 2018, with Theresa May ordering airstrikes against Syria without parliamentary support. May pleaded to operational necessity to justify her unilateral decision, but an opposition motion proposed by the Labour Party condemning her actions was rejected by MPs. Her successor, Boris Johnson, was also dismissive of any parliamentary input into this area, as was Rishi Sunak. So at best we can say that a convention might exist, but in practice doesn't appear to demonstrate that the government feels obliged to ask Parliament before it authorises the use of force overseas. So what do you think? Are conventions a good way of regulating political power? Or should they be replaced by more legal constraints on politics? Now, simply because the UK places a heavy emphasis on political constraints doesn't mean that legal restrictions also don't exist. And in the next videos in this series, we're going to explore these legal sources of the Constitution, the common law and constitutional statutes.